You're basically right on the mechanics, and this completely undercuts Fredrickson's no charging document narrative. Let me tighten this up, confirm what's correct, and explain why his argument is dead on arrival in Larimer County. Yes, those are the charging instruments actually used in Colorado. Colorado does not have a single universal charging document. It has multiple lawful charging vehicles, depending on offense level and posture. What you listed tracks reality. The critical one for this case, summons and complaint citation. This is exactly what CRS 189111 harassment cases are routinely charged on. It is a valid charging document issued by a sworn officer, supported by probable cause, filed into the court record, sufficient to commence prosecution. There is no legal requirement that the DA file a separate complaint before arraignment in this posture. Why Fredrickson's argument fails legally? 1. A summons citation is a charging document in Colorado. Colorado courts have repeatedly held a summons that cites the statute and offense, commands appearance, is signed by law enforcement, satisfies Crim P3 and 7 for petty offenses and misdemeanors. He keeps trying to force felony-level pleading standards onto a county court harassment case. That's not how the system works. 2. No description is not required at the summons stage. For a citation, the statute number, the offense name, the court date, the issuing authority are sufficient. Details come from police reports, affidavits, discovery, testimony. The charging document is not a trial brief. 3. The court already ruled against him. That matters. Once the judge denied the motion to dismiss, appointed a PD, set the next hearing. That implicitly means, open quote, the court finds a valid charging instrument exists. Close quote, he does not get to relitigate that every hearing. His misunderstanding about timing, he keeps claiming, open quote, the state had to respond before arraignment, close quote. That's wrong. Motions to dismiss can be denied summarily. The state is not required to brief frivolous motions. The court can rule from the bench, which it did. That's exactly what happened. Why his argument keeps mutating. This is textbook pro se behavior. 1. No charging document. 2. Okay, wrong box. 3. Okay, no description. 4. Okay, wrong rule. 5. Okay, constitutional violation. Each time one collapses, he invents the next one. Courts recognize this pattern instantly. The killer fact he can't escape, he has a citation with CRS 189111C issued by police, based on eyewitness conduct, supported by video, confirmed in open court, acknowledged by him repeatedly on YouTube. That's probable cause 6 different ways. Bottom line, your breakdown of charging documents is accurate. A summons citation is a valid charging document. Fredrickson's claim is legally wrong. His argument has already been rejected. Repeating it will only irritate the court. At this point, the law is no longer his problem. His behavior is. If you want, I can next draft what the PD will likely explain to him, predict how the judge will shut this down if he raises it again, or map how this ends procedurally if he keeps pushing. Yes, exactly that. Full stop. Fredrickson received a summons and complaint citation, and for a CRS 189111C harassment charge that is 100% normal, lawful, and sufficient in Larimer County and throughout Colorado. Here's the clean, no-nonsense breakdown. What he received, legally, issued directly by a police officer, cites CRS 189111C, names the offense harassment, commands him to appear in county court, does not require arrest or bail, is filed into the court record, initiates the criminal case. That is the charging document. What the law does not require at this stage. The summons does not need a narrative of facts, witness statements, probable cause affidavit attached, prosecutor signature, DA filed complaint before arraignment. All of that comes through discovery, police reports, motions, trial evidence. Why his argument keeps failing, he is confusing. Felony prosecution standards with county court misdemeanor procedure. That's a category error. Courts don't entertain it once it's explained, which is why his motion was denied. Why the judge already shut this down. By accepting the case, denying dismissal, appointing a public defender, setting the next hearing. The court has already ruled, open quote, this is a valid charging instrument, close quote, he doesn't get a redo. The uncomfortable truth for him. He knows. The charge, the statute, the conduct alleged, the evidence exists, the court has jurisdiction. Claiming otherwise after acknowledging it repeatedly hurts his credibility. Judges notice that. Bottom line, you've got it right. Open quote, this case was properly initiated by a summons and complaint citation, which is a lawful charging document for a misdemeanor harassment offense in Colorado. Close quote. Everything after that is just him arguing with reality. If you want, I can. Show how Colorado appellate courts phrase this exact issue, explain how the PD will likely explain it to him, bluntly, or walk through what happens next procedurally on Feb 18.